On the application of AM Belarus against the Secretary of State of the Home Department.
Mr. Dunlop.
My Lords and my Lady, I appear for the Secretary of State, the appellant. I lead Mr. Tabori. My learned friends, Mr. Drabble KC and Mr. Karnick, appear for the respondent AM. You should have, as well as the normal appeal bundle, a short supplementary bundle. The timetable gives me until 3:30 to make my submissions. Of course, if I can finish more quickly, I will. Can I set out the structure of my submissions at the beginning? It will be in 5 parts. The first is to go through the relevant statutory law and immigration rules. The second part will be to examine and make submissions on the Article 8 case law. The third part will be to examine the upper tribunal's decision. The fourth part will be to examine the Court of Appeal's decision. And the final part will be to go through the grounds of appeal, the 3 grounds of appeal, briefly summarising our position and briefly responding to some points made in my learned friend's case.
Thank you.
So, my Lords and my Lady, if I can begin with Section 1 and the statutory framework and immigration rules, can I take you, please, to page 497 of the amended appeal bundle, and if you're working from hard copy, that's behind tab 8 of tab.
I think, Mr. Dunlop, we're all working from the electronic
that's
copy.
Very reassuring to hear. Thank you. My own friend is not. So
right.
if you're on the first section of the authorities, which is big tab 8, you then go to little tab 1 behind big tab 8.
Bear with us just for a moment, if you would, please. In bundle 497.
Yes.
Thank you.
So this is sections 117A to D of the Nationality, Immigration and Asylum Act 2002. And these provisions give normative guidance to tribunals and courts about whether and when decisions under the Immigration Acts, which interfere with a person's right to respect for their private and family life, are justified under Article 8(2). If I begin with this page, section 117A, you can see from subsection 1, this part applies when determining whether a decision under the Immigration Acts breaches a person's right to respect for private and family life under Article 8. Subsection 2 clarifies what a court or tribunal must have regard to in considering the public interest question. And it says in all cases it must have regard to the considerations in section 117B. And then further, in cases concerning the deportation of foreign criminals, to the considerations listed in section 117C. And there's a dispute between us about whether this case was concerning the deportation of a foreign criminal. We say it was, because if AM is granted leave to remain, it will have a direct impact on whether he can be deported. A powerful tool that the Secretary of State has to persuade AM to tell the truth about his identity and thus to effect deportation is keeping him in limbo, to use that phrase. And if he is given leave to remain and lifted out of limbo, that tool will no longer be available and deportation less likely. Subsection 3 defines the public interest question. It refers here to an interference. Now, strictly speaking, that definition does not quite fit this case because, as we'll come to see when we look at the Article 8 authorities, a case like this is, if it's anything, a positive obligation case, not a negative obligation case. But what Parliament says about how the balance should be struck in a negative interference case must surely be taken into account by a court or tribunal in deciding, if one's looking at balance at all, at how balance in a positive obligation case should be struck. So I move on then to 117B, which is at page 499. Subsection 1 says that the maintenance of effective immigration controls is in the public interest. And we submit that this requires tribunals and courts always to have regards to whether a decision would damage immigration control. And that requires consideration in every case where someone seeks leave to remain outside the rules of whether making an exception in this case would weaken public policy. And that, we say, is relevant to ground 3 and the issue of deterrence. Subsection 4A concerns private life established when in the UK unlawfully. There's a typo in the Westlaw version. What it says, reading the full relevant parts, is little weight should be given to a private life or that is established by a person at a time when the person is in the United Kingdom unlawfully. Now, AM's Article 8 case was entirely based on private life. He does not claim to have family life in the UK, and such private life as he has in the UK was all built up while he was here unlawfully. Although he had temporary admission at periods, that is not lawful leave. It is merely an alternative status to immigration detention. And what section 117B4A does is it tells tribunals how to weigh private life established in such circumstances. And it tells tribunals and courts to give little weight to such a private life. And the effect is this, that in general, a private life in the UK established during unlawful residence will not be enough to outweigh the public interest in maintaining effective immigration control. It's not to be ignored altogether, but it is to be given little weight. And there is no exception built into section 117B4A for long residence of 20 years or more. And this links to ground 2. And what we'll say is that the rationale and purpose of 276 ADE immigration rules. What that does is it puts illegal migrants in a better position than they would be if they were to have to fall back on this generalised normative guidance.
But, I mean, within the notion of private life, you're going to get stronger and weaker forms of private life. So, I mean, there's some allowance, one might think, within the subsection for some variegation within the Article 8 framework and the period of time here. If, for instance, he had built up very strong relationships or had established a family, one might think those things would count.
Absolutely, accept that. And that's what the Supreme Court said, endorsing my Lord's comments in Ruppia. It said effectively that there is some flexibility built in here, and if there are particularly strong features of the private life, then it can, notwithstanding this normative guidance, it can be enough to outweigh the public interest in effective immigration control. Section 117B, subsection 5, it refers to precarious immigration status and says little weight should be given to private life established by a person at a time when their immigration status is precarious. Now, that doesn't actually apply here, although the upper tribunal wrongly thought it did. Precarious means leave to remain short of indefinite leave to remain.
So just so I follow that, you're drawing quite a sharp distinction between cases when someone has leave to remain and then you say they're here lawfully, but if they don't have leave to remain, and AM didn't, then you were saying they're here unlawfully for the purposes of subsection 4.
Yes.
And because of that distinction, 5 doesn't apply.
Yes. The upper tribunal, as I said, wrongly thought 5 did apply and it was a precarious case, but actually in each instance it does say little weight should be given, so that error in itself shouldn't have been material.
I mean, subsection 5 doesn't talk in terms of lawful presence or anything else. It just talks about immigration status. I'm just not quite sure why subsection 5 wouldn't apply in this case. I mean, I follow you say it applies in other cases as well, but it doesn't seem to depend on the distinction that you were seeking to emphasise in relation to subsection 4.
The case of Rupia looks at what 5 covers.
I was going to ask, is there authority that says
yes,
counts?
And what it says is this, in order for this to sort of, this must add something to 4A. And what it adds is it also covers those who've had leave to remain short of indefinite leave to remain. And for present purposes, it doesn't really matter whether it's both 4A and 5 or it's just 4A. Either way, it's little weight under the normative guidance.
Yes, right, thank you.
The status is more than precarious if you're within 4.
I'm sorry?
Status is more than precarious.
Yes, it's or worse than precarious, if you like. Yes,
Yeah,
yes.
worse, because
Yes.
you're saying 4 applies where you don't have leave, even though you're here, you
Yes.
haven't been kicked out. But 5 applies where you do have leave,
Yes.
but it's limited
Yes.
in some way. That's where the precariousness comes in.
Exactly. If I can then move on to 117C at 501. Subsection 1 sets out the general principle that deportation of foreign criminals is in the public interest. We don't need to go to the definition of foreign criminal, but it's not in dispute that AM is a foreign criminal as defined in 117D because of the length of the sentences he was received. Subsection 3 introduces exceptions 1 and 2, and exceptions 1 and 2 set out situations where what are sometimes called medium offenders, that's to say those who have not had a sentence of 4 years imprisonment or more, where they may succeed on either private life or family life Article 8 claims. And AM was a medium offender. His longest sentence was 3.5 years, shorter of 4 years. And here, the one that deals with private life is exception 1, and that exception 1 applies where A, C has been lawfully resident in the United Kingdom for most of C's life. And then it goes on to add additional conditions. But of course, for present purposes, we can stop at A because this claimant, or as he now is respondent, has never been lawfully resident in the United Kingdom. Now, although the statute doesn't say this, it's accepted that that's not the end of the matter, and there can be further exceptions if there are very compelling circumstances. Those are the statutory provisions I want to take you to. If I can now take you to the immigration rules, the key rule in force at the time is paragraph 276 ADE, which begins at page 506. It's the next tab for my learned friend's benefit.
Sorry, page?
506.
Thank you.
Now, this is the version of the rule that was in force at the time of the upper tribunal decision. And this rule enables certain illegal migrants who have lived in the UK unlawfully for a long time, but avoided certain kinds of proscribed behaviours to regularise their status. And before I go into the detail of it, I'll just give you our headline submission, which is that this rule lifts certain illegal migrants out of the difficulties they would otherwise be in under section 117B 4A.
Provided they qualify.
Exactly.
Exactly.
It provides an exception to that general rule that little weight is to be given to private life. And in our submission, that's critical. The question why have that exception is best answered by looking at who can benefit, who meets the suitability requirements. And if we look at now the structure of this rule, you can see that there are three things that you need to meet. The first is 1. Everyone needs to satisfy Roman numeral 1. Everyone needs to satisfy Roman numeral 2. But then the others are alternatives. There's 3, 4, 5, or 6. Now, Roman numeral 2 is just about making a valid application. So leaving that to one side, there's only one necessary condition which must always be satisfied in order to qualify for leave to remain under paragraph 276 ADE. And that necessary condition is Roman numeral 1. The applicant must not fall for refusal under the grounds specified in section SLTR, etc., which, as my lady rightly pointed out, those are the suitability requirements, as they're called. And I will come in a moment to those suitability requirements. But in summary, they require illegal migrants not to engage in certain behaviour. That's vital to understanding the purpose of this rule. It provides a benefit to certain categories of illegal migrants. And if you ask the question, why be generous to that category, it must be to incentivise illegal migrants to comply with the suitability requirements. Or to put it another way, to deter illegal migrants from the misconduct proscribed in the suitability requirements. Conditions 3 to 6 focus on either the length of the applicant's residence or the obstacles to return. And none of these conditions requires that residence be lawful. There are different tests depending on how old the person is. At all material times, the respondent AM was over 25. So in order to have met one of these, the only ones that were available to him were either 3, he'd lived continuously in the UK for at least 20 years, discounting any period of imprisonment, or 6, the very significant obstacles test. Now, in each of these conditions, 3 to 6, there are parentheses which discount any period of imprisonment for the purposes of counting the length of residence in the UK. And those parentheses reflect the fact that in Article 8 case law, there are certain kinds of lifestyle that don't attract the protection of Article 8. And so that's the logic behind why a time spent in prison shouldn't count in someone's favour. But even a short period of imprisonment, it might make a difference to whether someone has lived in the UK, for example, for 20 years. Those parentheses do not, of course, mean that all illegal migrants can qualify, no matter how serious their offending or how long their prison sentence is. On the contrary, as we'll see, the suitability requirements will disbar those with longer sentences. The only purpose of these parentheses is to ensure that short periods in prison shouldn't count in someone's favour. The suitability requirements begin at page 508. They are divided into 3 parts. There are mandatory grounds of refusal, And those are set out 1.2 to 1.8.
So just before we move on,
yes.
Paragraph 276 ADE, you said this is the paragraph as it stood at the time of the upper tribunal decision.
Yes.
Is that the paragraph, is it agreed that that's the paragraph that we're concerned with applying?
Yes, and I don't think there have been any, it's been moved to a different section of the immigration rules, but there are no substantive changes, I don't believe.
Right, okay, thank you. It might be useful at some point, not now, if we could be just given the reference to where this has been relocated in the current.
Yes, of course, my lord.
Thank you.
So page 508 are the suitability requirements. As I said, there are mandatory grounds of refusal 1.2 to 1.8. There are normal grounds of refusal 2.1 to 2.5, and there are discretionary grounds of refusal 4.1 to 4.5.
Sorry, normal were 1.1 and 1.
Sorry, mandatory are 1.2 to 1.8.
Yeah.
Normal 2.1 to 2.5.
Sorry, 1.2 to 1.8 are mandatory.
Yes.
Then
2.2 to 2.5 are normal. You can see if you're looking at SLTR 2.1 on page 509, the applicant will normally be refused on grounds if 2.2 to 2.5 apply.
yes.
And then the third category are the discretionary grounds, which are set out 4.1 to 4.5.
Yes.
So if we go back to the mandatory grounds, and I've set out our submission on this, that the effect of these suitability requirements is to deter certain kinds of behaviour. If an illegal migrant staying in the UK for a long time avoids these prescribed behaviours, then they have a route to leave to remain. They have 20 years route under 276 ADE. But if they don't, if they engage in the prescribed behaviours, then they cannot obtain leave to remain under the rules, and they face the much more difficult task of obtaining leave to remain outside the rules with all the obstacles that come with 117B4A. And if we look at the mandatory grounds of refusal, AM fails on several of these. We would submit up to 4, but certainly at least 2. Certainly 3. So 1.2, the applicant is currently subject of a deportation order. AM is.
Is it just one deportation order, or are there many of them?
I think there's just one.
Made in relation to a criminal proceedings, was it? Because there was a recommendation that he be deported when he was convicted.
That's right. There was a recommendation, and then a deportation order was made, and it's still extant. 1.4, he also applies. He is someone who has been sentenced to imprisonment for less than 4 years, but at least 12 months, and his presence in the UK is deemed non-conducive to the public good by statute. He is a foreign criminal, in other words. We would also say, if it had been necessary, we could also have relied on 1.6, the conduct of the offending. It's not necessary given 1.2 and 1.4. And we also say that 1.7b applies. The applicant has failed without reasonable excuse to comply with the requirements to provide information. And the information which he has failed to provide is the true information about his identity. We'll come back to that when we come to the findings of fact, but in essence, he's provided a name, school, factory ID, and those have been checked and found to be false, and those are the findings of the tribunal. So he also falls within 1.7b. no one of his name went to that school, factory ID is a forgery. So, we say the purpose of 1.7b is to give an incentive to an illegal migrant to provide the information the Secretary of State may ask for. If an illegal migrant with no passport or emergency travel document wishes to remain in the UK, they may not be inclined to provide the biographical data which the Secretary of State requests in order to facilitate their removal. The mere desire to be in the UK could be an incentive not to provide the information. And what this provision does is provide, if you like, a counter-incentive. It's an incentive to provide the information because if you provide the information, it might not lead to removal and you're still on track for leave to remain under the rules after 20 years, provided you haven't done the other prescribed misconduct, such as criminal offending. But on the other hand, if you don't provide the information, you may never be able to regularize your status. 2.1 to 2.5 are grounds where leave to remain is normally refused. But this is really focused on a situation where there's false information in relation to the application. Here there isn't, strictly speaking, an application for leave under 276 ADE, so that doesn't really apply here. 4.2 to 4.5 are the discretionary grounds of refusal, and they cover things like historic representations, non-disclosures, failure to pay NHS bills. And we say even leaving aside the criminality, etc., there would be discretion to refuse here under 4.2 and 4.3, because even on his own admission, he's made false representations. He admits his second asylum claim was false. And we say that these provisions here, 4.2 to 4.5, again, are to incentivize compliance, deter certain forms of misconduct. Unlawful migrants who are honest with the Secretary of State, disclose ministerial facts, answer questions truthfully, pay their NHS bills, they have the reward of being on track to leave to remain after a certain period of time. But those who do not lose that benefit. That's the intention.
So the ones relevant here are 4.2 and 4.3, is it?
Yes. So that's the first section of my submissions, looking at the statutes and the immigration rules. I turn now to the Article 8 case law, and I'm, if I may, going to divide that case law into two strands. The first strand is the case law on self-induced suffering. That is to say, whether someone can complain under the private life limb of Article 8 of suffering which is a foreseeable consequence of their own misconduct. The second strand will be on other Article 8 case law about when Article 8 imposes an obligation to grant a right of residence where the problems are not self-induced. So,
sorry, in relation to the first proposition,
yes.
is that a proposition that Article 8 is not engaged, or is it a proposition that self-induced suffering, foreseeable self-induced suffering, is relevant to proportionality?
Our primary submission is it's not engaged, and that's clear when you look at the case law that I'll take you to shortly. The alternative submission is that, and if it is engaged, it's a factor, if Article 8 is engaged at all in such circumstances, the fact that the suffering is self-induced should be the determinative factor in proportionality. In paragraph 28 of our statement of case, we've summarised, it's page 80 in the appeal bundle, we've summarised a principle which is now part of the clear and constant jurisprudence of the European Court of Human Rights, that Article 8 cannot be relied on in order to complain of personal, social, psychological, and economic suffering, which is a foreseeable consequence of one's own misconduct. And what I'll do, if I may, is I'll take you to the authorities we've cited here, which contain express articulations of that principle. But then I'll take you to some authorities in the immigration context where that principle has been applied in practice without necessarily always being described as an exclusionary principle. So if I begin with the authorities we've cited at paragraph 28, that's the first one is Denisov, which is page 909 in the appeal bundle. For those of us working from hard copies, it's in the second volume of the appeal documents. You got it. It's page 909 is where the judgment begins. It's a Grand Chamber judgment of September 2018. If I can just explain the facts and then take you to the relevant parts. The facts are these, that Mr. Denisov was a judge. He was president of the Kyiv Administrative Court. And the Council of Judges proposed his dismissal from the role of president for failure to perform his duties properly. And this decision was, to dismiss him from that role as president, was upheld by 2 tiers of domestic court. He was able to carry on as a judge, but not as the president. And he brought 2 claims to the European Court of Human Rights. An Article 6 claim that the proceedings in Ukraine had not been independent and impartial, and also an Article 8 claim. And if you begin at page 933, you can see the conclusion of his Article 6 claim. He won, in short. The European Court of Human Rights found at paragraphs 81 to 82, this is the summary of their conclusion and the reasoning precedes it, but in essence they found he hadn't had a fair determination. There's never been a fair proceedings to decide that he'd actually failed to perform his duties properly. So it was against that background that the Strasbourg court turned to the Article 8 claim. And the question arose whether Article 8 was engaged. Was this decision that he could no longer continue in his role as president an interference with his rights to respect for his private life? And this was the question that the court considered paragraphs 92 and following. And that's at page 935. And paragraph 92 makes a point connected to my Lord Stephen's question, my answer to it, that there is a strong tie, this is about 5 lines down, between the questions of applicability and merit. And if you look at paragraph 93 on the next page, 936, what the court do there is they summarize past case law, and there had been different approaches. Sometimes...
Sorry.
Yes.
Paragraph 92 begins, the present case concerns an employment-related dispute. And
Yes.
in that, there is a strong tie between the questions of applicability and the merits. They run the two together.
Yes.
In this context.
Yes. But as we'll see when we come into the judgment, the principles they lay down are not limited to employment-related context. But what they point out is that in previous cases, the court has taken up this matter either at the stage of admissibility or at the stage of merits. Paragraph 95 to 98 is very general guidance on what private life means. It's under the heading General Principles, private life is a broad term, and the authorities they cite in these paragraphs are certainly not limited to employment-related disputes. You have a reference here to S and Marper on paragraph 95, which is a case about police holding criminal data, personal data. And then at paragraph 97 to 98, there's under the heading right to respect for reputation. But then if we look at the wording of paragraph 98, it begins by referring to loss of reputation. It says, it's important to stress that Article 8 cannot be relied on in order to complain of a loss of reputation, which is the foreseeable consequence of one's own actions. But then it goes on in the next sentence to explain that the concept is wider. It says, in Gilberg, cited above, the Grand Chamber did not limit this rule to reputational damage and expanded it to a wider principle that any personal, social, psychological, and economic suffering could be foreseeable consequence of the commission of a criminal offence and could not, therefore, be relied on to complain that a criminal conviction in itself amounted to an interference with the right to respect for private life. I stress this because my learned friend has made the submission that the Gilberg principle shouldn't be extended beyond cases of reputational damage, but here the Strasbourg Court is making clear that it does go beyond that. And the final sentence is also important because it extends the principle beyond just criminal convictions. It says this extended principle should cover not only criminal offences, but also other misconduct, entailing a measure of legal responsibility with foreseeable negative effects on private life. And in our case, we say that AM's suffering, any suffering he has as a result of being in limbo, is the foreseeable consequence of misconduct on his part. And that misconduct includes not just criminal offending that led to deportation, but also the misconduct in entering the UK illegally and preventing his removal by lying about his identity. And we say that has the foreseeable negative consequence that he's living in a country where he doesn't have lawful status, including, for example, the right to work. So, returning to the judgment at paragraphs 100 and following, the Grand Chamber then sets out general principles on private life and employment-related scenarios, as they describe it. And paragraph 100 explains effectively how ability to work is part of private life. And you can, if you go over the page 938, reading down through 101, you can see that what they describe as employment-related scenarios are not limited to employment by the state. They also cover situations where an individual loses work outside public service or cannot work in a certain profession. And we say that this case, our case before you, raises similar issues because AM's principal complaint about his limbo status is that it prevents him from legally working in the UK. What paragraph 102 does is it sets out two situations in which a decision that restricts what work someone may do may engage Article 8. There's alpha and there's beta. Now, alpha is where the private life is the reason for the decision, and beta is where the decision has sufficiently serious consequences. And then, if we move forward in the judgment to page 942, This is where the court begins to apply those principles to this case. And they say at paragraph 120 that the alpha situation doesn't apply. This is not a case of someone losing access to certain work because of their private life. It was nothing to do with Mr. Denisov's private life, what happened. So then they move on to the question of the consequences. And at paragraph 121, what they do before they get into looking at the consequences is they effectively ask, well, is this his fault? They ask, does this Gilbert exclusionary principle apply? They set out the principle again. According to that principle, where the negative effects complained of are limited to the consequences of the unlawful conduct which were foreseeable by the applicant, Article 8 cannot be relied on to allege that such negative effects encroach upon private life. Now, the reason that they don't apply that here is set out in the rest of the paragraph. That whereas in Gilbert the unlawful conduct was largely undisputed, in the present context the applicant contested the very existence of any misconduct, thus implying that the measure involved his legal liability could not have been a foreseeable consequence of his conduct. And that's why they distinguish Gilbert. Now, my learned friends in their statement of case focus on the word contested, and they appear to submit that the Gilbert exclusionary principle can't be applied if the misconduct is contested or challenged, even if that challenge has been fully and fairly resolved by the courts and the misconduct found proven. And that can't be right. On that logic, the Gilbert exclusionary principle would only apply to criminal offenders who plead guilty, not to those who plead not guilty and are convicted. What my learned friend's submission overlooks is the fact that Mr. Denisov was successful in Strasbourg. Strasbourg found that the misconduct alleged against him had never been established by a fair and independent tribunal. That's what distinguished his case. And the next case I'll take you to confirms that merely contesting misconduct alone is not enough to avoid the Gilbert exclusionary principle. So just to finish the facts of that case, what happens is they find that the severity of the consequences were not such as to engage Article 8 for Mr. Denisov, because effectively he could still be a judge.
So there was a balancing exercise conducted? There
was, because the Gilbert principle didn't apply. The next case is Evers.
They ran it together, didn't they? They ran the balancing with into admissibility.
Yes, I mean, I probably shouldn't have. I should have qualified my answer when saying there was a balancing. Well, they never get as far as saying Article 8 was engaged, and the reason they don't is because they look at the severity of the consequences. So if that counts as balancing, then yes, there's balancing. But they never get as far as saying Article 8 was engaged. What's the balance between the interference and the justification?
That's implicit, isn't it? If you say that the severity of the consequences don't meet the threshold required, there's a balance, isn't there?
Well, there is. That's why I agreed in answer to the question. There is a kind of balancing going on when you're looking at how severe are the consequences, but strictly speaking, it never got past admissibility. It never got on to, yes, there's an interference, was it justified? The next case is Evers, and in our submission, this shows that the Gilbert exclusionary principle is not limited to employment disputes, and still less just disputes about reputation. Much broader principle, and that begins at page 967. It's behind tab 20 in the same bundle for my learned friend's benefit. Now, the facts of this case were that the applicant, Mr. Evers, had lived with his partner and her daughter V, who had a mental disability. And Mr. Evers had had sex with V, and V had become pregnant. And the state brought criminal proceedings against Mr. Evers for having sex with someone who couldn't resist. The criminal proceedings were discontinued because there was insufficient evidence that V had no capacity. But later, V was placed in a residential home. And on the recommendation of V's guardians, and after hearing evidence from experts, a civil court approved a contact ban, prevented E from contacting V. And that is what Mr. Evers was complaining about. He was complaining about not being able to contact C, his stepdaughter V. And he very much contested any misconduct. He said that V was a consensual adult and he'd done nothing wrong in having sex with her. And the Strasbourg court considered whether Article 8 was engaged at all in this case. And if I turn to page 978, paragraph 52, the court states that this is not a family life case. We're looking at private life. Paragraph 53, they make some general observations on the breadth of the concept of private life, and they cite, amongst other cases, Denisov. Paragraph 95 on page 979 begins in this context, and this, of course, was not the context of employment-related dispute. And they here set out, almost word for word, the principles set out in paragraph 98 of Denisov. And again, they reiterate that this principle is not limited to reputational damage, expanded to a wider principle: personal, social, psychological, economic suffering. And they again reiterate not just criminal offences, but other misconduct. And then in paragraphs 56 to 57, they effectively give two reasons why Article 8 is not engaged. The first reason at paragraph 56 is that V doesn't want to see Mr. Evers. The second reason is an application of the principle in Denisov to the case before him. I'll just let you read paragraph 57. I'll summarize in my submission what it says. In summary, they effectively find that Mr. Evers had engaged in misconduct, abusing V and seeking to continue that abuse, and it was a foreseeable consequence of that misconduct that he would be banned from seeing her. Therefore, he can't rely on Article 8.
It seems to be based on, in effect, a warning given by the Traunstein Regional Court to him. And the foreseeable consequence is of the applicant's intention to continue frequenting V. So it's not looking back to what he had done previously. It seems to be based on court, makes it clear that's how the court views it, and yet despite that warning, V continues seeking to frequent V.
Yes.
That's a bit different from saying he disputed that he'd done things wrong in the past, because this doesn't seem to be based on things done wrong in the past. It's things done wrong after he's been warned by the Traunstein Regional Court.
Well, the reason why the Traunstein Regional Court warned him was because they accepted the evidence of the experts that he had done things wrong in the past. But yes, I certainly accept that the misconduct, if you like, that they're focusing on at the end of paragraph 57 is the intention to continue frequenting V. But it's not a coincidence, in my submission, that they are using this phrase foreseeable consequence, having 2 paragraphs earlier set out this rule that you can't complain of foreseeable consequences of your own misconduct. The third of the authorities that we rely on for this express articulation of principle is called Belicta Spingolu. Apologies if I've mispronounced it. It's page 885, and for my learned friend, it's tab 17 of the same volume. My learned friends submit in their statement of case at paragraph 42 that this case shows that the Gilbert principle is not an exclusionary bar. Well, that, as I'll show, is wrong. It would be surprising if a principle which is termed an exclusionary principle is not actually an exclusionary principle. And actually, this case doesn't show that. This is a case where the Gilbert principle didn't apply because the consequences of which the applicant complained were not foreseeable. So to understand that, you need to know the facts, which are somewhat complicated, but I'll summarize them as succinctly as I can. The applicant had been convicted in 2001 of membership of an illegal organization. She was sentenced to 12.5 years and prohibited from holding a civil service position. She successfully brought an earlier claim to Strasbourg in respect of that. It's paragraph 6. She didn't serve the full sentence she was given because the sentence was reduced in light of a new criminal code, and she was released from prison. And then she was given a writ of execution, which is referred to in paragraph 7. But the key thing about that is it had a date on it. It said her sentence would be complete on the 2nd of September 2012. And that date was significant because the way Turkish law operated meant she'd be able to take up a post in the civil service when her sentence was fully served. So what happened was she passed a civil service exam, but was banned from taking the job. And she went to the authorities to complain and to ask for the first writ of execution that had this important date on it. What happened was, when she went to go and get this writ, she was imprisoned on the basis that she hadn't, in fact, served the full term of imprisonment. She needed to serve another 5 days. And the authorities, Turkish authorities, said the date in the first writ had been wrong. And they produced a second writ of execution. The second writ is for your note, it's referred to at paragraph 19, but it has a completely new date of 11th of July 2013. And she complained about this because it delayed when she could start work in the civil service. By the time when Strasbourg was hearing her complaint, this date had passed and her right to work in the civil service had been restored. So her complaint was about the past period. And in particular, it was about that period of just under a year between the date when the first writ of execution said her sentence to be complete and the date in the second writ of execution. And she complained under Articles 6 and 8. If I can take you to the bit where the Strasbourg Court looks at Article 8. It begins at page 898. And you can see from paragraph 53 that neither party contested the application of Article 8, but the Strasbourg Court nonetheless considered it of its own motion because it went to jurisdiction. And paragraph 54 the Strasbourg Court again reiterates the general principles that I've taken you to from Denisov. And it doesn't start in this context. Now it starts to begin with, and then it makes the same point about foreseeable consequences. It makes the same point that this is not limited to reputational damage, but it's a wider principle. And then, sort of about halfway down the paragraph, having set out the general principle, they say that they need to determine, first of all, whether that principle applies to this case. And they explain why it doesn't in the 4 or 5 lines at the bottom of the page that begin, "Be that as it may." They set out there that the applicant contended the domestic court's decisions and the restoration of rights proceedings had not been foreseeable because, in her view, by not rectifying the second writ of execution, they had unlawfully returned her to the conditional release regime and thus prevented her from benefiting from the restoration of rights. So, in effect, what they were saying was that B's complaint was about unforeseeable consequences that came from changing this date in the writ of execution. She wasn't complaining just about not being able to get a job in the civil service for a period. She was complaining about the unforeseeable length of that period. And that is why the Gilbert principle didn't apply. So the rest of the judgment, which my learned friend relies on, where the court looks at the severity of the consequences for her, that's only relevant because those consequences were not foreseeable. Only because the complaint was about a period where she couldn't have foreseen she would be prevented from working the civil service. So, to sum up this case law and the principles from these cases, we say that there are effectively 2 questions to ask when an applicant complains under Article 8 that they are suffering, for example, economically or psychologically, for example, because they can't obtain the work they want to have. And the first question is the applicant suffering, for example, their inability to work legally, is it a foreseeable consequence of misconduct that is either undisputed or established by a fair and impartial tribunal? If so, they have no complaint, they can have no complaint under Article 8. It's only if the answer is no to that first question that the court then looks at whether the consequences of being unable to do the work they want, for example, are serious enough to engage Article 8.
In the immigration context, what's the breadth of that exclusionary principle? Looking at the facts of this case, you would say it applies. how do you limit it to other circumstances where there has been a failure to provide information, which really hasn't got much of impact at all?
Well, if it didn't have much impact at all, then we wouldn't necessarily be a foreseeable consequence. It comes down to that test of foreseeability. If that's the question my Lord is asking. There is a separate question that I'll come on to in due course, which is, why is this sort of situation different to deportation? Yes. So, I mean, strictly speaking, we're focused on this case of suffering from limbo. So that's really the thing we need to focus on, but the thing I need to establish. But if one asks why not deportation, I think I would put it to the words in the test. It's if you're complaining about suffering, personal, social, psychological, and economic suffering, you're complaining about your current life in the member state, then the Gilbert principle may apply if what you're complaining about in your current life is a foreseeable consequence of your misconduct. Deportation, you're complaining about something different. You're complaining about an action the state is going to take that will result in a very different life, take you to another place. So in a way, I think the reason why these principles have never been applied in a deportation case is because, if you like, those are complaints about acts of the state that are going to involve a big sort of interference in someone's life by taking them out of the place they live and putting them somewhere else. Whereas these sort of cases are where someone is complaining of the status quo and the state's failure to alleviate the suffering they find themselves in.
How does that work with one of the cases that you rely on? Is it Dragan, where there was an expulsion? There was an interference, just like a deportation order.
Yes, well, Dragan is an early case, and I'm just about to go to it, so perhaps if I go to it, I can explain. What happened is, in a lot of these cases before we got to Denisov and Evers and Bingolu, the court would sometimes look at this issue of foreseeable consequences of misconduct as an admissibility question, sometimes as something that went to the balance to be struck. And it's in the more recent case law that they've codified the position that it's something that goes to admissibility. But if I can then take you to Dragan. Dragan is one of 3 Strasbourg cases which we submit can be seen as the sort of starting point or the building blocks that led towards the Gilbert exclusionary principle, where some sort of similar common sense principle is applied, that you can't effectively complain of things that are your fault. Well,
before moving to that, an individual comes to this country unlawfully, makes a false asylum claim, and foresee that if the asylum claim is not going to be granted, he's going to be deported. But Article 8 is always engaged in such circumstances, considering the family life that is built up or the private life that is built up in this country. So why does your Gilbert exclusionary principle not apply in such circumstances?
Well, it depends what you're complaining about. If you're complaining about the fact that you are unable to work while you live unlawfully in the UK, then the Gilbert principle applies, because you're complaining about your present suffering in the UK. If you are complaining about prospective removal to another country, the deportation to another country, then you're complaining about something different, not your present suffering. So the wording of the Gilbert test simply doesn't apply.
But your liability to removal will be a foreseeable consequence of doing the things that Lord Stevens has said.
Your liability to removal will be, but the
And they're psychological, social, and economic. So that seems to fit the Gilbert mantra.
Yes, but the Gilbert mantra talks about complaining about suffering, and I'm suggesting that the reason why that's never gone as far as it's never been extended to a deportation case is that you're not in a deportation case complaining about your present suffering, your present inability to work, or whatever it may be. You're complaining about something in the future.
Why does that make a difference in Article 8 terms? I'd never been conscious that Article 8 drew a difference between present suffering and future suffering. Just looks at suffering. I'm trying to explain why there seems to be a different approach when it comes to the situation of present suffering, which falls within this Gilbert test, and the consequences in the future. And the best I can do in trying to understand why it hasn't gone into deportation cases is to draw that kind of distinction. It can be either a distinction between the present and the future, or a distinction between an act and an omission. Thank
you. So the Gilbert case is the English translation is in the supplementary bundle. Dragon, did I not say that?
Gilbert.
Sorry, my mistake. The Dragon case that I was about to come to is in the supplementary bundle, the translation. The facts, this was obviously decided...
sorry, what page?
It's page 1. Sorry, the translation begins...
It's just the...
It's in the, page 9 of the supplementary bundle.
Yep, thank you.
And when you say it's a translation, is this a translation by the court? Or
no, it's a translation by the Foreign Office of a judgment or decision that's in French, published only in French by the Strasbourg Court. It was decided on the 7th of October 2004, so long before...
So sorry to be picky. Do we have the French judgment as well in the bundle? If not, can it be supplied in due course?
Of course.
Thank you.
So this was decided on the 7th of October 2004, before Gilbert or Denisov. The facts were that Ms. Dragan, the first applicant, was a Romanian national who had lived in Germany, was deported from Germany to Romania, and then she was returned to Germany, where she renounced her Romanian citizenship. And this, at the very least initially, made removal impossible. And there was a dispute between the parties as to whether Romania later indicated might take back some ex-citizens, including someone in her category. And she and her children were subject to expulsion orders and were not given residence permits. And she had health issues, and she and her children complained under Articles 3 and 8. Her complaint under Article 3 was dismissed as manifestly ill-founded. The complaint under Article 8 begins at page 25. And at the bottom of page 25 is the reference to Article 8. Going over the page, the top paragraph is a complaint which relies very much on her length of residence, 14 years, the personal ties there. The court has a paragraph halfway down the page, the court notes, and that paragraph cites some general case law. I'll just emphasize, for present purposes, the last sentence, that the duty under Article 8 doesn't, and you're picking up the last words, generally prohibit the expulsion of a non-national purely on the basis that he or she has been in the territory of a contracting state for some time. And then the final aspect of what I'd say from that is there isn't a sort of a 20-year rule in Strasbourg case law. The final aspect of the reasoning is at page 27, and the Strasbourg court begins by stressing that they've never had a residence permit, and they mention the fact that enforcement's not been possible because of their renouncement of the Romanian nationality. And they say, well, but this didn't lead to a decision to remove their obligation to leave. Consequently, the applicant's deportation doesn't constitute a lack of respect for their family life. The fact that the applicants refuse to return to Romania and intend to stay in Germany cannot be considered relevant. And so it then goes on to dismiss it as manifestly unfounded. And what we say is that in essence, the Article 8 complaint is rejected because they've never been there lawfully, and the obstacles to deportation were of their own making. So we say in substance that was an application of the same sort of principle, which then later founds the Gilbo principle, what you might call a common sense principle, that if you create a situation, a difficult situation for yourself, you can't then complain of it. Specifically in an immigration context, if you enter a country unlawfully and thwarts deportation, you can't then pray and aid your long residence in the country to make an Article 8 claim. And that's, we say, should have been dispositive in this case too. Now, the next case we rely on is Shevanova. Both parties have relied on judgments in Shevanova. We rely on the Grand Chamber. My learned friends rely on the first section decision. They've submitted in their statement of case that the Grand Chamber decision effectively doesn't in any way undermine the first section decision. It's not, they say, because of a failure in the reasoning of the first section, the Grand Chamber came to a different view. They submit that the only reason the Grand Chamber struck out the case was because the Latvian authorities had offered permanent residence. And you might think, reading that there'd been some change in the position between the first section decision and the Grand Chamber decision. There wasn't. There was no material change. Ms. Shevanova had been offered permanent residence before the first section decision. The only way of reading the Grand Chamber decision is overturning the first section decision. So, with that introduction, can I take you to the first section judgment, which is at 1262, behind tab 29.
I'm so sorry, I missed the page.
1262.
Thank you.
And this is the first section judgment, which is 15th of June 2006. The facts are at paragraphs 12 and following. In short, the applicant in that case, Ms. Shevanova, was not someone like AM who'd arrived in a member state as an unlawful migrant. On the contrary, in 1970, at the age of 22, she'd settled in the Latvian part of the USSR for work. And she was a citizen of the Soviet Union, so this was lawful. She lived in Latvia from 1970 onwards, right up until the date of the case, so for 36 years, with only short work-related absences in 1995 and 1996. For 7 years of her time in Latvia, she was married. She gave birth to her son there. And she and her son still lived there at the time of these ECHR proceedings. And so it was not in dispute that she had forged strong personal, social, economic ties in Latvia. Now, what happened, and it's important to grasp the facts to explain what this judgment says, is that in August 1991, this is paragraph 13, Latvia regained full independence. And in December 1991, the Soviet Union, of which she'd been a national, broke up, and she therefore became stateless through no fault of her own. And her name in August 1992 was entered in the Register of Residents in Latvia as a permanent resident. Then, picking up the story at paragraph 14, she's offered a job in the Caucasus, and she's advised to obtain Russian citizenship. She'd had 2 Soviet passports, and she'd lost one, got a new one, found the old one. And she got someone to put a false stamp in the old Soviet passport. And that stamp falsely stated that the registration of her residence in Latvia had been cancelled. And she used that passport with a false stamp to register herself in Russia and obtain Russian citizenship, because that was, she thought, she was advised it was going to help her with her job application. So what happened then was later, 4 years later, she applied to the Latvian authorities for a passport based on the status of permanently resident non-citizen. And in the course of considering this application, the Latvian authorities became aware of what she'd been doing with the earlier passport. And they refused the application. They made a deportation order. And that was served on her in June 1998. And the deportation order wasn't actually enforced, but she was detained for 16 days. And that's at paragraphs 26 to 27. So what then happened, if we pick it up at paragraph 29, is after she'd complained to Strasbourg, but before the first section had given its judgment, the Latvian authorities made her an offer. On the 7th of January 2005, so some year before this judgment, the Latvian authorities, based on her strong private and social ties, offered her a residence permit. And so by the time the first section was hearing the case, there was no longer any threat of deportation. And so the only thing she could complain about was her past limbo. The fact that she had spent 7 years without lawful status and had 16 days of detention. And it's precisely because she wanted reparation for that she didn't settle the case. You can see that, page 1274. Paragraph 40. She wasn't prepared to settle the case just on the basis of getting permanent residence permit. She wanted redress for the 7 years of limbo, if you like. And so the question for the court was whether she was a victim in relation to those 7 years of limbo. And this is the question on which the first section and the Grand Chamber came to different conclusions. The first section begins their consideration of whether she's lost the status of a victim at paragraph 42. And then if you turn to page 1276, paragraph 46, the court notes that the Latvian authorities haven't acknowledged any violation of Article 8. And what they conclude in paragraphs 47 and 48 is that she is still a victim in relation to that past limbo. And if you pick it up at the last few lines of paragraph 47, they say that that solution, in other words, the residence, doesn't erase the long period of insecurity and legal uncertainty she's undergone. And so the redress is only partial. And if you look at the last sentence of paragraph 48, they say that the adverse consequences haven't been wholly erased. So they then go on to examine the Article 8 claim. But the odd thing about the judgment is that they focus on removal, whereas they should be focusing on the 7 years of past limbo. And so if you look at paragraph 64 and following, they go through some of the familiar authorities in a deportation case, cases such as Bulteef and so on, and they effectively find that deportation wasn't justified. It wasn't proportionate. And then they go on in later, paragraph 85, to give her damages. This case is then referred to the Grand Chamber, and the Grand Chamber's judgment, which is dated 7th of December 2007, begins at page 1296. And the Grand Chamber comes to a very different conclusion, strikes the case out of the list, no damages, and they focus on the correct thing, which is the years of limbo, not the deportation. Nothing has changed in the meantime. You can see that if you go to page 1303, this is the end of the section dealing with the factual circumstances of the case. And you can see that the sort of last relevant factual circumstance is still back in February 2005, before the first section judgment had been handed down. It was this offer of residence, no material factual change. So they then go on to look
where did we see that on 1303?
paragraph 35.
Thank you. Yes. Thank you.
So they then look at the Chamber's decision, the party's observation. We can pick up the court's assessment at paragraphs 44 and following. But sorry, just before I take you there, can I take you to what the way the government was putting it at page 1305? And the government's submission, paragraph 41 on page 1305, was, if you look at the second sentence, they didn't deny a period of insecurity and legal uncertainty. However, they considered that the measures taken against her had been the consequence of her own unlawful and fraudulent conduct, and any ordeal she'd undergone had resulted from her own actions. So this is long before Gilbert and Denisov and so on, but the government submission is sort of along the same lines. And then if we look at the court's assessment, paragraph 44, page 1306, they say they don't need to decide whether at the time she lodged the application she could claim to be a victim. In other words, they don't need to look at the deportation case, which was what was the principal focus at that time, because in light of the events, and there's no she's been offered a permanent residency. So, and they say at paragraph 46, there's no real risk of deportation. So what remains is this period of limbo, and their consideration of that is paragraph 48. And can I just ask you to read paragraphs 49 and 50, and I'll make a short submission on what I say is a principle to draw from. So in my submission, the key factor here is that the limbo the applicant was complaining of was the result of her own misconduct.
But they don't say Article 8 doesn't apply. They say it's a sufficient remedy.
That's right, because the question for them is, was she a victim of any Article 8 violation in relation to the past limbo? But that's quite a similar question. Are you a victim of what's happened in the past under Article 8, or does Article 8 apply? Similar issues. So yes, I agree it's not exactly on point with the Gilbert principle, but it has underlying it the same principle which we'll see domestic courts have also applied, that if what you're complaining of is uncertainty, limbo, if you like, that is a foreseeable consequence of your own misconduct, self-induced limbo, then you can have no Article 8 complaint. You are not a victim.
But they don't say that. They say the remedy that's been offered by the Latvian authorities, the regularisation of her stay by giving her a residence permit, is an adequate remedy. That's different from saying she has no Article 8 complaint, isn't it?
Well, they've separated out the two strands of her Article 8 complaint. There's the complaint about deportation, for which the residence grant is an adequate remedy. And then the issue for them is, what about that past period of limbo? And the first section had given her damages effectively for that past period of limbo. The Grand Chamber says, no, that was her fault. That past period is not something that needs to be redressed because it was a result of her own actions. And as for the other separate complaint...
Well, in fact, they say resulted largely from her own actions, last sentence of paragraph 49. So it's not, they don't say she's exclusively responsible.
No, I accept that. It's not quite on a par with the wording in Gilbert. They don't use the phrase foreseeable consequences, but it's a similar, I would say, common sense principle that underpins it, that you can't complain of the foreseeable consequences of your own misconduct.
So but you separate it out and you say the deportation attracted the remedy, whereas the limbo period attracted no remedy at all.
Yes. The final Strasbourg authority, which I'll take you to if I may, and only briefly, before we come to some of the domestic authorities in this field, is Ramadan. It's a judgment of 2016 before Denisov. The facts are different, but it is an immigration context. It begins at page 1246. Sorry, it doesn't begin at page, but it begins at 1224, but the part I'm going to take you to is at 1246. So it's a complaint about the renunciation of Maltese citizenship. And Mr. Ramadan had obtained Maltese citizenship as a result of a marriage that was only entered into for the sake of obtaining that citizenship. And the only things I just draw to your attention is how the court interprets Dragan and Chevanova and how it looks at the complaint before them. The complaint before them was effectively that as a result of this renunciation, Mr. Ramadan was left stateless and in a kind of state of limbo. And the Strasbourg court found no violation of Article 8 for various reasons. One of them being, in effect, that the fact of renunciation of citizenship was a foreseeable consequence of his misconduct. If I take you to page 1246, paragraph 89, this is one of the key reasons they find that there's no need to assess negative obligations under Article 8, no violation. They say here, paragraph 89, in the last sentence, moreover, the court cannot ignore the fact that the situation complained of came about as a result of the applicant's fraudulent behaviour, and any consequences complained of are to a large extent a result of his own choices and actions. And there's a footnote there, 41. If you look down the page, 41 refers to the Grand Chamber decision of Chevanova on the 7th of December. And that, we say, is, if you're looking at what principles to draw from Chevanova, the important judgment. And it's, again, the court is here saying that it's one of the reasons for finding no Article 8 claim here is because of this. He's complaining of a limbo that arose as a result of his own fraudulent behaviour.
But isn't this on the predicate that Article 8 does apply? I'm just looking at the language in paragraph 89 itself. That all seems to be directed to an answer to a case which is within the scope of Article 8, not arbitrary.
No, my Lord. Ultimately, the conclusion is that Article 8 doesn't apply. If you go back to paragraph 84,
Paragraph
84 on page 1245, they set out the general case law on denial of citizenship, and they make the point that, if we look at the last sentence, that sometimes an arbitrary denial of citizenship might in certain circumstances raise an issue under Article 8 of the Convention because of the impact of such a denial on the private life. So the context is denial of citizenship may sometimes raise an issue under Article 8, sometimes not. And ultimately, they conclude not in this case for various reasons, including the fact it's his fault. And paragraph 94...
Well, isn't it because it was not arbitrary? 89 says the decision was not arbitrary and it was only arbitrary denials.
Yes.
Yeah. Because it was his fault.
Yes. On page 1247, you see ultimately the conclusions there, paragraphs 94 to 95, simply don't need to look at negative or negative interference or positive obligations and no violation. And then there's you see footnote 49, referring to the last sentence of 92. Footnote 49 refers to Dragan, and the sentence that goes with at the end of 92 is that the fact that a foreigner has renounced his or her nationality of a state does not mean in principle that another state has the obligation to regularize his or her stay in the country. Those are the Strasbourg authorities I wanted to take you to in an immigration context where the courts have applied a principle that you could see as something that evolves into the Gilbert exclusionary principle, or you could see as something very similar to it. And it's a principle, we say, rooted in common sense, that you can't blame the state for problems of your own making. And that, we submit, would explain why the domestic case law that I've taken you to adopts a similar principle without seemingly being aware of all or any of this Strasbourg case law. And so
that to be misconduct, or can it just be your own conduct?
Misconduct, applying the test in the Strasbourg authorities. It starts off with cases on criminal offending, it expands it to wider misconduct, but it doesn't go beyond misconduct. I'll go through the domestic cases that we've relied on, and I'll also address in chronological order RA Iraq when that comes. So if I begin with Abdullah, that's page E543. For my learned friends' benefit, it's volume 1, and it's tab 8 in the first section of authorities. I'm sorry, is it tab 8? No, tab 5. The facts were summarised in our statement of case, paragraph 33. It was an appeal against a refusal of asylum and leave to enter by a foreign national who had lied repeatedly about their identity and nationality. The judge found that they may be Palestinian, and it was for the Secretary of State to make inquiries. And Mr. Abdullah said he should have Article 8 leave in the meantime. But the judge said they were not satisfied Article 8 was engaged, and Mr. Abdullah appealed. And the only ground was whether the judge had erred in holding that Article 8 was engaged.
Was not engaged.
Was not engaged. Thank you, my lady. And the leading judgment was from Sir Stanley Burnton. If I pick it up at page 547, paragraph 14, you have the submission on behalf of the appellant. And I draw attention to it really because it's a very similar submission to the submissions that have been made on the part of the respondent AM in our case. And effectively, picking up on the third line in paragraph 14, Mr. Jacobs, on his behalf, was complaining about Mr. Abdullah's life of limbo. Without leave to remain, he could not lawfully work in this country, and we'd be deprived of any social security support here, save under Section 4. And in these circumstances, Article 8 requires the Secretary of State to grant him leave to remain in this country, at least pending any further attempts to obtain Saudi agreement. So that's the submission. At least until you can remove, you should grant me leave to remain. And paragraph 19, this is under the heading discussion, where Sir Stanley Burnton sets out his reasoning. And can I just ask you to read paragraph 19 and the first sentence of paragraph 20? So the situation there was very much the same situation as here. And ultimately, what was really critical, paragraph 20, first sentence, was that the situation was of his own doing. And we can see at paragraph 22 how Sir Stanley Burnton then applies that fact to the Article 8 analysis, having first at paragraph 21 dealt with some obiter dicta about rationality and cadia and distinguishing them. At paragraph 22 is the judge's conclusion on Article 8, and he dismisses the appeal on the ground that the immigration judge was entitled to conclude that the date of this decision, Article 8, didn't require the Secretary of State to grant leave to remain. If Article 8 was engaged, there could be only one answer to the balancing exercise required by Article 8.2, namely that the refusal to grant leave to remain was justified. And we respectfully echo that. When I answered my Lord Stephen's question, and I said our primary submission is not applied, our fallback position is that the claim should have been dismissed, even if Article 8 is engaged. And we say, we respectfully agree with Sir Stanley Burnton that if it's a self-induced limbo, then really there's only one way of striking the balance, if there is indeed a balance to be struck. The second case chronologically is Hamzy, which begins at page 567. It's a judgment of My Lady. It's tab 7 for my learned friend's benefit. The claimants were undocumented Iranians, and if you pick it up at paragraph 49 on page 584, what made them irremovable was effectively the breakdown in relations between UK and Iran. And as a result of that, the UK couldn't at that time obtain an emergency travel document. It doesn't, of course, follow that these applicants couldn't have got passports for themselves if they'd wanted to return voluntarily, but enforced removal was not possible. And My Lady at paragraph 50 made these general observations about why the fact that you can't get enforced removal doesn't in itself mean you should get leave to remain. And effectively there are 2 points. This paragraph's been cited in the statements of case, so I'm not going to sort of read it all out, but to summarize it, the first point is that if there were such a policy, it would create perverse incentives to obstruct removal. And the second point is the situation might change. And we would submit that that first point about perverse incentives is another way of putting what we've called deterrence. Refusing to grant leave to remain to those who cannot be removed by force, but could go if they cooperated, deters people from obstructing removal. And those are the sort of introductory paragraphs of the judgment. They're, at page 588, you see issue 3. And paragraphs issue 3, we say, is the same issue as in this case. It's really, does limbo require a grant of leave? And paragraph 74...
Sorry, it's framed in terms of a disproportionality analysis, isn't it?
It does.
So this doesn't seem to be an authority that Article 8 doesn't apply at all.
It doesn't. This would have to be fit within the sort of fallback submission that if Article 8 is engaged, then there's only one way to strike the balance, as Sir Stanley Burnton put it.
I think you do rely on this as having been cited to the upper tribunal.
Yes.
As a way for you to avoid the consequences of not having directly raised the exclusionary principle. But it doesn't help you on that, does it?
That's right. It's not putting it in terms of an exclusionary principle. And our case, from the start, from the upper tribunal onwards, has always been the article claim must fail. It must fail because this is self-induced limbo. And to some extent, it doesn't matter to us why it fails, whether it's because Article 8 is not engaged or because the balance can only be struck one way. This is an authority that the Article 8 claim must fail. You're absolutely right, my lady. It doesn't say that it must fail on the grounds of Article 8 not being engaged, although arguably Abdullah could be seen as that. But Sir Stanley Burnton was agnostic as to whether it was engaged or something where the balance could only be struck one way. The Abdullah case was cited here at paragraph 76. It effectively is applied at paragraph 77, where my lady said very similar considerations apply in this case. The ultimate conclusion at the end of that paragraph is that any state of limbo they find themselves in is self-induced. And we say that is the correct approach, whether you see it as something that excludes Article 8 or something that leads to only one outcome. It's correct that should be the determinative factor in a case where the limbo is self-induced. Now, the next authority, chronologically... Sorry,
I'm just on
yes.
that. My lady's formulation of the perverse incentives point at paragraph 50, I mean, it seems to me that's fully in line with a disproportionality analysis, because that's identifying an aspect of the public interest, which would have to be taken into account on the disproportionality analysis.
I agree with that. That's why really, grounds 2 and 3 and our points on deterrence and so on, they come into play if you don't accept that there's an exclusionary principle and if you're looking at a balance. The next authority domestically, chronologically, to take you to is R.A. Iraq, which begins at page 727. It's tab 11 in that first volume, right near the back. And it's important to note that this was not a self-induced limbo case. This case involves someone who arrived as a child, who was granted leave to remain. His leave to remain wasn't extended because of his criminality, but the reason he couldn't return, be removed was because of the country guidance situation in relation to Iraq. And you can see that page 730. The situation was that he was, due to the country guidance situation, unreturnable to Iraq. And if you look at paragraph 23, Judge Allen, summarising the situation, it says in the third or fourth line of that indented quotation, that the circumstances there were whether he can neither be removed or make lawful voluntary departure. So this was a case on its facts to do with, if you like, the other kind of limbo, non-self-induced one, and the guidance which is given should be understood in that context. Now, the judgment looks at the cases of Abdullah and Hamza, which I've taken you to, and then it gives guidance which you find at page 739. The guidance breaks it down into 4 stages. For present purposes, we can look at stage 4, the balancing exercise. And if we go over the page to page 740, paragraph 70, if I just pick up those first few lines, as they're relevant to our ground on deterrence. The public interest in question is principally the public interest in maintaining an effective system of immigration control and in deporting those who are in the UK illegally. There is no separate public interest in preventing such individuals from, for example, working or relying on benefits or gaining the full range of free healthcare. Parliament has, however, decreed by statute that such benefits and opportunities are to be withheld from those here illegally. Parliament must be taken to have intended that the lack of such benefits and opportunities will form a disincentive to coming or remaining here illegally. And pausing there, this is why I stress that is it's relevant to ground 3. One of my learned friends' submissions is that deterrence is not in play, and we say, of course it is. The whole context is, and the whole purpose of limbo is as a form of deterrence.
I wonder if it is just about deterrence in relation to maintaining an effective system of immigration control, because it might be said that Parliament has chosen to what extent resources will be made available by the state to persons who are here illegally. In other words, we just will not dedicate so many resources to persons here illegally as would be dedicated to persons here legally or who are citizens. That doesn't seem in itself to be a deterrence point. It seems to be more a focusing of resources point.
That part of it is, though I accept that, but I think the focus here was probably on the opportunities of working lawfully, for example, and the purpose in depriving people from working if they don't have leave to remain is deterrence. So I accept that there may be other purposes too, but certainly a principal one underpinning the...
Well, often I think it's said that where persons are denied a right to work, it's to protect the labour market for citizens or persons who are here lawfully. And again, full range of free healthcare, that seems to be a question of dedication of resources.
Well,
I appreciate these aren't your words. These are.
No, I think probably the proper way to look at it is as both. And the phrase that's sometimes used of limbo is a compliant environment. And the word compliant implies an intention to make people comply, which is another way of saying deter people from not complying.
So what do you say about the appropriateness of this guidance, generally?
I say, first of all, it doesn't really cover self-induced limbo. It doesn't give clear guidance on that at all. And secondly, it's okay if read carefully, but in some aspects of it can be misread.
If one's thinking about a conventional Article 8 situation, the first question is Article 8 engaged? If it is, then you go on to address the questions of whether it's in accordance with the law, pursues a legitimate aim, and is necessary in a democratic society. And I was just wondering why one has stage 1, 2, 3, and 4, which don't really address those issues. No doubt the factors in them would be relevant, but why? Why is it necessary to have that gloss?
It isn't necessary. I'm not... It's not a necessary part of my case to unpick the 4 stages, but it's certainly not my case that they are necessary. I don't really, for example, understand why you need to have a stage 3 of fact-specific analysis and a stage 4 of balancing. Effectively, you end up doing much the same sort of things in each of those 2 stages. I think stages 1 and 2 are to effectively limit or filter off some cases where you couldn't even begin to get an Article 8 sort of limbo argument off the ground. I think that's what they're trying to do.
Well, I just had difficulties in relation to stage 1, which makes a distinction, which obviously exists between prospective limbo and actual limbo. But shouldn't one just be concentrating on the way it affects family life, how it affects the individual? And so I was just wondering why that distinction, which obviously affects the underlying impact on the individual, is of importance, as opposed to concentrating on the underlying impact on the individual.
Well, I accept your point, my lord. I don't think it is essential to go through these 4 stages, and one could simply look at it in terms of the impact on the individual. Now, whether you look at that as through the Gilbert principle, or whether I'm wrong about that, and that just simply comes into that there's something that may be a determinative factor in a balance, but doesn't preclude Article 8. That may be a simpler way of looking at it.
On your first point, Mr. Dunlop, whether it's self-induced or not, it is slotted into the structure of RA, isn't it? At stage 3 is 0.5.
It is.
But your point is it doesn't give us any guidance.
Exactly. It doesn't. It tells us that's a sort of something you look at, whether it's due in part. It doesn't tell you what you do if you conclude it wasn't just in part, it's entirely because of him. He's the reason. Well, what are you supposed to do with that? It doesn't tell you.
Thank you.
Paragraph 71 is an example of something that is said obiter dicta, which is capable of being misread. In answer to my Lord Hamlin's question, this is one of the things I was thinking of when I said it's okay if it's carefully read, but it can be misread. What it says in paragraph 71, and I stress the words might be said, it says the principal basis on which it might be said that the public interest in continued limbo may be so weakened such that Article 8 rights or other convention rights might tip the balance will normally, and again I stress normally, only arise in cases where it's clear that the public interest in effective immigration control is extinguished because in practical terms there's no realistic prospect of effecting deportation within a reasonable period. Now, if one doesn't read that carefully, one could think that that is effectively saying that the public interest will come down in someone's favour if there's no longer any prospect of removing them. That couldn't be right. It ignores the situation of the self-induced impossibility, and it also focuses exclusively on the public interest in removing that particular individual, and doesn't think it doesn't refer to or address the other aspects of the public interest. For example, the public interest in deterring others from being non-cooperative.
I mean, for myself, I also wonder whether it misses the dimension of the public interest that I was raising with you about allocation of resources, just generally.
Yes, I think that's right. So what is sort of floated as a potential situation in which a claim might succeed shouldn't be taken as sort of definitive guidance that you will succeed in these circumstances, because actually there are other aspects of the public interest you need to take into account, and there are other facts that might make it an unviable Article 8 claim, namely if the impossibility of removal is entirely down to the person lying about their identity. Now, in fairness to Lord Justice Haddon Cave, he then does quote what my lady said in Hamza. It says further, and then adds it at paragraph 72, but it's really not obvious how you are supposed to balance 71 and 72.
It's more however rather than a further.
Yes. The last case on this question of sort of self-induced suffering in the domestic authorities is the case of Antonio, which begins at page 551. It's behind tab 6 of the authorities. And it concerned a foreign national who had lied repeatedly about their identity and their nationality, claiming to be Jamaican and Portuguese. He submitted that Article 8 required him to be granted leave to remain. And he lost in the upper tribunal and the Court of Appeal. If you pick it up from paragraphs 44 and following on page 564, here the Court of Appeal quote from the judgment of Judge Rintoul, Judge Rintoul in turn relies or quotes both R.A. Iraq and the judgment in Hamza, and ultimately the way the Court of Appeal sum it up is in the first sentence. In fact, the judge also summed it up in this way. The first sentence after that quotation. As the judge said, the appellant was and is the author of his own misfortune. And then goes on to deal with the irrationality Kadir point. But in our submission, this shows that if RA Iraq guidance is applied carefully enough, it doesn't preclude what we say is a common sense approach, where if you are the voluntary and capacitous author of your own limbo, by lying about your identity, that should be fatal to your Article 8 claim.
So just to be clear, this is being done as part of the Article 8 balancing exercise rather than
Yes, that's right. Yes. As I've said, unless there's some reason why the Gilbert principle doesn't apply in this context, we think applying that principle, the correct analysis is that Article 8 is excluded, but it doesn't matter to us as much as the outcome matters. What matters to us is that even if there isn't an exclusionary principle, the fact that someone is the author of their lone limbo should be the determinative factor in a balance. If they're capacitous, it would be very different if they didn't have the capacity to tell the truth. They're delusional, they couldn't remember their name. That would all be very different. But in a situation where someone has the capacity and voluntarily chooses to lie, that should be the determinative factor, we say.
Mr. Dunlop, I had, and please excuse me because it's obviously my fault, I had some difficulty in understanding the submissions you made about past suffering and future suffering in the Gilbert principle. And I was just wondering whether during the course of the hearing, either tonight or tomorrow morning, it might be possible for that to be reduced to writing. Exactly what it is that you are suggesting should be the principle that should be applied.
Of course, my Lord.
And how it doesn't impact on deportation.
Yes, of course, my Lord. And I'm sure the fault was mine. So the second strand of case law, which we've dealt with in our statement of case under Article 8, involves Article 8 and illegal migration and rights of residence. And this is at paragraphs 36 and following of our statement of case, which is page 83. Paragraph 36 summarizes a distinction which is drawn in the Strasbourg case law, for example, in the Grand Chamber judgment of Jeunesse, between settled migrants and illegal aliens. And effectively, what they say is that if you're withdrawing a right of residence from a settled migrant, that's treated as an interference, whereas in other cases, where it's someone who's there illegally and they're complaining about the fact that they've not got a residence permit, it's a positive obligation case. But either way, the principles are similar when you look at whether a fair balance has been struck.
And I think in the Court of Appeal you accepted, or at least it's recorded, that you accepted that it didn't matter whether it was a positive obligations or a negative obligations
That's right.
case.
Yes.
It's all about fair balance.
Yes.
And is that still your position?
Yes. The next point that I want to make, I don't think it's necessary to go to Jeunesse, partly because it doesn't matter, partly because we'll come on to another authority about it. But the next point that I wish to make, summarising the case law we set out, paragraphs 37 to 39 of our statement of case, is that the Strasbourg Court has really only found a positive obligation, as far as we can tell from the case law. The only cases where they found a positive obligation to regularise the status of an illegal migrant, there are two scenarios. One is they have family life, that's the Jeunesse case. And the other kind of scenario is where, through no fault of their own, they are irremovable. And those are cases like Hoti and Keita. And neither party's identified any Article 8 case for this one, where the Strasbourg court has found that the right to respect for private life, as opposed to family life, requires a member state to regularise the status of an illegal alien who entered illegally as an adult and could return to their home country if they wished. And we say the first category of cases, the family life cases, they're obviously very different, Jeunesse being an example. And the Gilbert-Schleusy principle would have no purchase in a family life case. It's only about private life. And it's one thing to expect an individual to bear the foreseeable consequences of their own misconduct. It's quite another to expect blameless family members, including children, to bear those consequences. The second category are the cases where someone is stateless through no fault of their own. In paragraph 39 of our statement of case, we've given two examples of those cases, and these are cases relied on by my learned friend, the cases of Hottie and Cater. And these are not cases of foreseeable consequences of misconduct at all. They are people who were stateless through no fault of their own. And even in that context, the Strasbourg court didn't say there was automatically a positive obligation to grant them residency. Rather, the phrase that the Strasbourg court used is the phrase you find at the end of subsection 1 and subsection 2 of paragraph 39 of our statement case. That's page 85. And the phrase that the Strasbourg court uses is that there's a positive obligation to provide an effective and accessible procedure enabling the applicant to have the issues of his further stay and status determined with due regard to his private life interests. And in each of those cases, the claimant succeeded because of many factual features of the case, such as the length of time they had to live in limbo, and the obstacles that were put in the way of them being able to obtain status as stateless persons. But the principal point is they certainly were not people who had lied about their identity, who were in a state of limbo due to their own misconduct. The only authority that we've been able to find that provides any sort of guidance on whether private life alone might oblige a state to grant leave to remain to someone who's an illegal alien is this case of Poor Mez, which I will just take you to briefly, which we cited at paragraph 38. And it's at page 1208. It's the second volume. Sorry, it begins at my apologies, it begins at 1195, I believe. And it's behind tab 27 in the second volume. But the general principles begin at 1208. At paragraph 56, the court refers to the sort of previous case law on when there's a positive obligation to admit an alien into the territory. And if you read through the sort of factors that the case law has identified, you'll see that most of them, or many of them at any rate, involve family life. So it would begin with such as the extent to which family life is effectively ruptured, the extent of the ties in the contracting state, that is a private life factor too, but going on, whether there are insurmountable obstacles in the way of the family living in the country of origin of one or more of them, and whether there are factors of immigration control, e.g. a history of breaches of immigration law, or considerations of public order weighing in favour of exclusion. And if you strip out the ones that relate to family, you're really left with two things. You're left with ties to the contracting state, and on the other hand, factors of immigration control or considerations of public order. And what the Strasbourg Court does at paragraph 58 is it says, it sort of adapts that guidance to the private life context. And if you pick it up around the middle of the paragraph, the court finds that similar considerations apply in respect of an alien who's established social ties amounting to private life in the territory of a state during a period of unlawful stay. They go on to say that the factors set out in paragraph 56 apply to the extent possible to cases where it's more appropriate to focus on private life. And they add, equally, if an alien establishes a private life within a state at a time when he or she is aware that his or her immigration status is such that the continuation of that private life in the country would be precarious, a refusal to admit him or her would amount to a breach in exceptional circumstances only. And my learned friend says, well, there's exceptional circumstances. The upper tribunals used the phrase exceptional circumstances, so it's fine. They were applying the right kind of test. But, of course, exceptional circumstances can mean different things in different contexts. And it's telling in our submission that neither of us have been able to identify a case where these exceptional circumstances have been found to be met. Certainly not in a case where the person is responsible for their own predicament. If I go back to our statement of case, page 86. What we've done at page 86 is that we have referred back to that parliamentary guidance that
Which number paragraph?
Paragraph 41 to 43 under the heading parliamentary guidance.
Thank you.
We've cited there in paragraph 42, the case of Rupiah, which I mentioned in response to a question from my Lord Sales. And perhaps I could just take you to that judgment and that part of it. It begins, well, the relevant part is 1545, so that's volume 2. Tab 42. Begins at 1545. It was a case of an overstayer, not a foreign national criminal. They'd been in the UK for just over 20 years. For the first half of that time, they'd had lawful status. And in fact, by the time of the judgment, they'd been able to get leave under 276 ADE because they hadn't committed any crimes or anything like that. But the relevant part that I cited that I wanted to take you back to because it endorses what my Lord Sales said about some degree of flexibility. That's at 1559. And if you pick it up at B, Lord Wilson says, under B, inbuilt into the concept of little weight itself is a small degree of flexibility. And he says it also section 117A2A provides limited degree of flexibility. And then he endorses at the end, just before the indentation, the words of my Lord Justice Sales as he then was, and what my Lord said then in that indented quotation at D is that, you pick up the last few lines, such generalised normative guidance may be overridden in an exceptional case by particularly strong features of the private life in question. And we say, when it comes down to the analysis of the upper tribunal, they don't apply this, they don't identify exceptional strong features of private life. On the contrary, they find that AM has only established a minimal private life. Now, there was one last authority to take you to before I get on to the section on the upper tribunal's decision, the third section. It's about 3 minutes to 1 according to my watch. Would you like me to go to that authority and deal with it now, or should we?
I think we'll rise. We'll rise now and we'll sit again at 2 o'clock.
Thank you, Mark.
Thank you very much. Are you on course?
Yes, I am.
Thank you very much. 2 o'clock then, please.